Hey everybody, welcome to our Thursday night live. John Skiba here from the Consumer Warrior YouTube channel. And each and every week, like we do on Thursday night, I do a live Q&A to answer questions, answer your questions over debt collection lawsuits, bankruptcy, how to deal with serious debt problems. That's what we do here. I am a consumer protection and a bankruptcy attorney in the state of Arizona. And this is where I practice. And so if you're in Arizona, I'm happy to talk to you. My contact information will be below. And if you actually have a case you want to work with us, feel free to reach out. For everybody else around the country, I'm happy to talk about and share general information about this process. You shouldn't interpret this as legal advice because I'm not licensed in your state and I don't know the laws in your state. And so I always say, take this for what it is. This is people talking on YouTube. But along those lines, if you do have a question or something that you would like to discuss in the group today, go ahead and put it in the comment section. And I'll go ahead and put it up on the screen and we'll discuss. Try to give some pointers and maybe some resources where you can find information on how to deal with these various things. So I always like to start off by going into the YouTube channel and going through the comment section and finding questions that I think have some broad applicability. So I had a few of them here I wanted to go over real quick today. So while we're going over those, if you do have a question, go ahead and throw it in there and I'll try to get to it today. This is a question I get fairly frequently. This person says, I have literally zero assets. My car is on a loan, and they said I'm getting laid off. I got served with a summons. If I don't do anything and they win, how much per paycheck could I expect them to garnish? A couple things here. So it is true that sometimes it's possible to do nothing. You know, if you don't respond to the summons and the complaint that they served on you, eventually a default judgment will be entered against you. The problem with the default judgment is they can do things like you said, like wage garnishment, bank levy. They can lien real estate in some states. And not only that, but like in Arizona, civil judgments last for 10 years, and then they can be renewed for every 10 years for the rest of your life. And so they're sitting there just churning interest. And so even if right now you don't have assets or your job situation is such that it's going to be tough, they may be able to, 10 years from now, your situation, hopefully will have changed and they can come after it then. So it's very rare when I recommend the do nothing situation. It's usually when people have completely exempt income source like Social Security and they don't have assets and don't anticipate getting any assets in the future. How much could they garnish of your check? Well, it says in there that you're getting laid off. So if you're not employed, they can't garnish anything, obviously, because there's no paycheck. If you are employed, that's going to vary from state to state. In Arizona, they can take 25% of each check, which is a huge chunk. And I can tell you that's sort of the tipping point for a lot of people of actually filing for bankruptcy, because a bankruptcy will stop wage garnishment immediately as soon as we file it with the court. But there's some states like Texas doesn't have wage garnishment, which is always kind of surprising to me that they don't. But it's one of the few states out there that they can't garnish your wages. They can garnish in Arizona, like bank accounts. They can go in and sweep the account. So not responding to the lawsuit and not trying to resolve and deal with it and just letting a default judgment be entered into it is always very risky. Not only that, they usually add attorney's fees and court costs, everything like that on top of the amount that they're seeking if you don't respond to it. So you got to be real careful with that. All right. Another question I saw on the channel said, do you need to answer an amended complaint if you've already answered the original complaint? So periodically, the creditors will file, they file their summons and complaint. You file an answer to it, and then they find the need to amend the complaint. Sometimes maybe there's a fact they need to change, or there's an additional party they need to add. The question is yes. If the complaint is amended, they're going to provide you with a copy, and you typically have the same amount of time to respond to that one as you did the other one. I've seen people just kind of blow off the amended complaint and they end up with a default judgment against them. So got to be very careful with that. All right, let's do a bankruptcy question. Can I file Chapter 7 or 13 before I go into debt? I'll be losing all of my overtime and hours cut back. I want to get ahead of everything before I can't pay loans I have out. Okay, I'm assuming the question here is, can you file a Chapter 7 or 13 bankruptcy before you go into default or before you fall behind on your debt? And The answer is yes. And you don't have to be behind on your bills. I have a lot of people that contact me here in Arizona who they're completely current on all of their creditors, their monthly payments, all that. Everything's current. But a situation like this, they see the dark clouds are coming. The hours have been cut back. There's no more overtime, and there's no way they're going to be able to make ends meet. Yes, you can file a bankruptcy case, even if you're not behind. And frankly, it'll actually help your credit score a bit because you're not going to, your credit score is going to drop from when you file, and it falls from where it's at. So if you have credit that's over 700 and you file bankruptcy, it'll fall. But compared to if you have a credit score of 600 and then you file, it's not going to fall as far. So a couple things to think about when it comes to filing for bankruptcy. You don't have to be behind on it. You don't even have to have debt. That's what's kind of surprising. That's always kind of the follow-up question. How much debt do I have to have? I don't know why you would file bankruptcy if you didn't have debt, but there's no specific dollar amount that you have to have in order to file in there. So, all right, let's jump into some of the questions. First of all, Al, thank you. Currently from Pine Top. Awesome. If you're in Tucson, if you're not from Arizona, Tucson and Phoenix are miserable this time of year. Let's look and see what it is. The temperature in Arizona right now, it's a balmy 107 degrees. And so Pine Top is up in the mountains. There's so many people that live in the Phoenix area that are unaware that just a couple hours to the east of us, there is it's a 7,000 feet thick pine trees, all that kind of stuff. My wife actually grew up in Pine Top, so I know the area very well. Thank you for supporting the channel. Sam asked, do I take Nevada cases? I went to law school in Las Vegas, at the University of Nevada, Las Vegas, but I'm not licensed there. So no, I don't. You can still contact us, and we do have referral sources. You can also go to the National Association of Consumer Advocates. Their website is consumeradvocates.org. And they also have a directory of consumer attorneys like myself who might be able to help you out. But let's see if we can help you out. Sam says, can debt collectors be allowed to use discovery findings from the federal lawsuit? I'm a plaintiff towards his state lawsuit or your defendant, if both are parallel running. Yes. So if the information is part of the lawsuit, it's likely discoverable. It's also, it may even be public, depending, like if there was a ruling, they can use, there's actually some legal principles. Like if the court rules one way in one case, they can actually use it against you in another. It's called res judicata or collateral estoppel, claim preclusion, sometimes we'll call it, or issue preclusion. Those types of rulings can be used against you, and they can be used as defenses as well. But yeah, they can likely discover that. If there's additional information in the federal lawsuit, they could request that to be used in the state lawsuit. All right, let's see here. James says, I take it your issue to summons must be properly served, if that's correct. Yes. The service of process, particularly in these junk debt buyer lawsuits, it's always a big mess. I can't tell you how many people I talk to every single day who have a default judgment and they know nothing about it. And that's because of the way, particularly in Arizona, but I know in other states as well. So the traditional way is that they file the lawsuit with the court, and then they have a certain window, like in Arizona, it's 90 days to serve you with the complaint and the summons. Now, service in Arizona requires that they send a process server over, or a constable or a sheriff. It's almost always a private process server. But they have to come by your house and they have to put it in your hand. Or they can leave it with someone, the law says, of suitable age and discretion, which that could mean a teenager. But it has to be someone who lives with you. Could be one of your kids, could be a spouse, could be a roommate that happens to just live with you, whatever. So they can actually serve that person with the complaint and summons. And that counts as service. But if they can't get you home, if they can't, if you live in a gated community, if you don't ever answer the door, sometimes they have the wrong address, they can go to the court and request for what's called an alternative service order. And the alternative service order nowadays in Arizona it usually requires them to send a copy of it to your last known address, certified, as well as come and tape a copy of the complaint and summons to the door. And when they do both of those things, that's what starts the clock ticking on your response time. So you have to be served properly before they can enter a default against you for not responding, but you got to be careful with it. My advice to people is typically just take it head on. Just get don't dodge service. And I get beat up all the time in the comments section on YouTube for this. I've just seen it go south so many times where people are trying to dodge service. Eventually, there's a mechanism wherever you live in the court for them to be able to serve you if you're avoiding it. And so you might be able to, dodge it for now and not have to deal with it. But then 6 months from now, you may end up with a default judgment that you didn't even know about. So there's defenses to it. There's ways to defend it, to maybe settle it. There's bankruptcy options, whatever it is. I think it's better to deal with it and know exactly what you're dealing with rather than to just hope, that it just goes away. So hopefully that is helpful there with service. But that's one of the tricky things. If you haven't been served correctly, if it's something where if you're in that situation, you have a default judgment that's entered against you and you didn't receive it, it is possible to get it set aside. It's just much more difficult to get that set aside once it's in place. You have to be able to come in and show that you didn't get served properly, which is always hard because you're kind of trying to prove a negative, prove that something didn't happen. And then you have to be able to find evidence out there that it didn't happen, not that, because the court will believe them. There's a presumption in the law that they did if they submitted it. So hopefully that is helpful. All right. Last call for questions. Otherwise, we'll wrap this up for tonight. Something I did want to do that would be really helpful to me. You may have noticed if you subscribe to the channel that I'm doing at least 3 videos per week plus this live stream. With those additional videos, I want to make sure I'm hitting topics that are relevant to you. And so if there's something that I haven't discussed, feel free to put it in the comments here or put it in the the comments of the thing. I do read the comments on the YouTube channel. I can't respond to all of them. The channel gets a lot of views and there's a lot of comments, and I have to do my day job as well. But I'm always looking for more ideas and that to produce videos on. So, all right. Hey, thank you, Aiden. I appreciate that. It says, for what percentage can doing a debit card settlement with Synchrony Bank? If Synchrony Bank still has the debt, they haven't sold it to a junk debt buyer, settlements usually happen around the probably 30 to 50, 30 to 60% range. If it's been sold to a junk debt buyer, you may be able to get a lower settlement, particularly if you have some type of hardship that you can show them. If the creditor who you took the loan out with is the one that still has it, they're going to demand a higher settlement. They know that their position is stronger. They know if they sue you, they're going to have the witnesses, the documents, all that kind of stuff that they need. But if they've sold it to a debt buyer, they may struggle to be able to prove that in a court type setting, and they may take less. They also have less skin in the game because they may be, paid 5 to 10 cents on the dollar for the account. And so they don't have as much invested in it to lose. So that's what I would recommend. All right. Sam says, I heard the Arizona statute of limitations is 3 years. If I move to Arizona, I can't get sued, right? Well, the Arizona statute of limitations is 6 years on credit card debt. Now, there's a discrepancy in the law, and that's why if you're just researching this online, it gets a little bit confusing for Arizona. But it says that the Arizona statutes say that with revolving accounts, the limitations period, the statute of limitations is 3 years. If it's a written contract, it's 6 years. And so for quite a long time, I would defend these lawsuits, and the judges hated this because the credit card's kind of both, particularly in the old days when there's an actual written agreement that would send you in the mail and you'd sign off on it. And so the legislature addressed the issue, and now those two statutes are still there. The revolving accounts are 3 years. The written contract is 6 years, but it says specifically now credit card accounts are 6. So 6 years is the amount of the time that they have to sue you from the time the account goes into default. Now, you bring up another question that I actually just did a video on just recently. Part of the question is, what if you live in a different state? Let's say you live in California or you live in New Mexico, and then you move to Arizona. Whose statute of limitation applies? Now, this is actually a more complicated question you think, and it's often not as clear cut as a lot of people think, because what it breaks down to is they look at whether the statute of limitations. A lot of courts will ask, is it substantive law or is it procedural law? Most courts interpret it to be procedural, and if it's procedural, then the place where you live, the place where the lawsuit was brought, that's where that statute of limitations will govern. So, I mean, I think it's always an argument. If you come from a state that has a shorter statute of limitations, and then you move to Arizona that has a larger one, but that it's something I would allege and something I would use as defense, but it's a little trickier than you might think. So, all right. Josh says, wondering how someone does a payment plan for their attorney during a Chapter 7, since payment has to be done before filing or it can be discharged, right? This is a good question. And this is actually kind of a hot topic, if there is such a thing as a hot topic in the bankruptcy world. Traditionally, how Chapter 7 bankruptcies, the legal fees and the court's filing fee in a Chapter 7 bankruptcy was done is that everything had to be paid up front. And that's how most of my legal career, the bankruptcy cases, the Chapter 7s at least, that's how they were done. And it was always just, to me, it was this thing that just didn't make any sense, that the kind of the rules and the courts required that, because, I'd have clients who were coming to me at probably their most difficult time financially. And we were saying, hey, we need a couple $1,000 to get this done. And that, most people didn't have that money sitting around. So they had to either borrow it from family or have friends and family help out, or they would save up or get on a payment plan and not file the case. The problem with that is, until you file that bankruptcy with the court, creditors can still keep doing collections. They can garnish wages. They can file lawsuits, and it's a big, mess. And the idea behind that, the reason why that rule is in place, is because with the bankruptcy, Chapter 7 bankruptcy, if the agreement was entered into prior to filing bankruptcy, and then you file bankruptcy, any contracts that you enter into before bankruptcy like that, the debt can be discharged. And so there'd be no obligation to pay the debt. The kind of work around it that some creative attorneys have done, and the courts, at least in Arizona, have said we could do it, is through what's called a bifurcated fee agreement. Essentially, we have two. So like with my law firm, we do Chapter 7s, most of them on what's called a zero down option. We don't require any money up front. We filed the initial petition with the court, which is just like a 3 or 4 page document. That gets the order in place that stops collection. And then we finish the rest of the case from there. It's set up on a payment plan where the legal fees are paid out over 12 months. And the way that's allowable is if there's two separate representation agreements, an agreement before filing that covers the work associated with that, the bankruptcy case is filed, and then the client and the attorney enter into a second agreement after the bankruptcy case is filed that covers all the work associated with the post-filing to finish out the case and payment plans, all that kind of stuff. So, Josh, that's a really long explanation about how that is, but that's a change that's afoot nationwide in the bankruptcy. Some states are okay with it, others are not. In the state of Utah, I know that just here in Arizona, the courts issued an opinion basically providing that this could be, attorneys and clients could do this as long as it was structured correctly, and as long as clients kind of really understood what was going on. Like I said, in Arizona, I think most attorneys you talk to now will be doing the zero down Chapter 7 with the payment plan. That's how we do it here. So, all right. James said, my understanding is that arbitration costs $3,000 to $5,000. Do I have an estimate of the amount of lawyers won't touch because of the cost of arbitration? I think you're talking about private arbitration. Because we often talk about filing a motion to compel private arbitration, and it's true. So private arbitration, these are private companies. They're kind of like quasi court. They're not associated with the government at all. They're just companies that have rent a judge. They have these lawyers that are private arbitrators. The filing fees are quite expensive. Like one of them is AAA, the American Arbitration Association. Another one's called JAMS. I can never remember what JAMS stands for, but it's an acronym. Both of them, they have very high filing fees for corporate parties, like a junk debt buyer or like an original creditor. And with most of them, it's right around $2,000 to $2,500. Plus, you have to pay for the fees of the arbitrator. Whereas the consumer side of it, they don't, I think the filing fee is like $200. So my experience is that usually, particularly cases where it's like under 10 grand that they're seeking, filing a motion to compel, the other side will either try to settle it with you, or they may even just walk away from it. So that's the reason why. And I've also said it kind of throws a wrench into what it is that they do as far as their debt buying and debt suing machine, because that's not how most of them play out. So, all right, let's see here. Ryan had a couple questions. Question about wage garnishment. Can they garnish my VA disability monthly payment? And I got your correction there. No, certain funds are exempt. Social Security, retirement, Social Security disability, VA disability, those funds are exempt and they're protected under federal statute. And so if they were to try to garnish those, whether it be directly or whether it's in a bank account, they will, you can object to it. I should say this: they can try to garnish it, but you can object to it. And where usually they're not going to try to garnish, like Social Security Administration or the VA, anything like that. Where I see it is they try to garnish a bank account that contains Social Security or the VA money, and then you can raise the objection to it. And this brings up a kind of a little practice pointer. I tell people, if you're receiving Social Security or the VA, my recommendation is that you have a bank account that's set aside solely for those deposits, that you don't put any other funds in there. Because even in a bank account, those funds can be considered exempt. However, if those funds are commingled with employment income or income from some other source, they could lose their exempt nature because the court can't really tell what's employment income and what's Social Security. So my recommendation is to have an account set aside specifically for that. And then, if you have another account where there's side money coming in, so you can just transfer funds over there and then you can spend it, but keep those funds totally sequestered, totally separate. So, all right, I think that'll do it for today. But hey, everybody, thanks for checking in. Again, if there's topics you would like me to address in the videos that we put out each week, let me know. I'm happy to do that. I'm actually looking for more topics that I can that would be helpful to all of you. And thank you for everybody tuning in and that supports the channel each and every week. And we'll catch you next week.